All right, guys, come on in here. Come on in here. Come on in. We don't have a lot of time. I wanted to do this breakdown today. Hey, guys, it's your legal bestie, attorney Symone. And today we are breaking down the biggest bombshells from the government's closing arguments in USA versus Sean Diddy Combs. So buckle up. The prosecution has laid it all out. The law, the facts, and the receipts. This video is just going to be about the prosecution's closing statements. I'll do a separate one about the defense. Also, I've been attending trial live each day. And yesterday after court, I gave a brief recap on the courthouse steps, but the sound was bad. So I wanted to redo this. This is going to be a quick, concise summary of the highlights. Let me know your thoughts in the chat below. Hit that like and subscribe. Share it as well. We are trying to see if we can get to 80,000 subscribers by the end of the trial. We're right almost at 75,000. And you can always go to my website, which is SymoneRedwine.com, to book a consultation with me or to get my book, Background Checks 101, The Beginner's Guide to Finding Out Who the Heck You're Really Dealing With. One of the first real bombshells was when they broke down RICO. Of course, we know what RICO is. I'll say it real briefly. I've been covering RICO. I've already made a video here where I talked about how I believe RICO was proven on the second week. The prosecution really brought RICO together. I'll say this, their tone for the day, it wasn't Johnny Cochran. I mean, it was pretty boring, okay? Jurors were falling asleep periodically. Some were taking notes. And it appears that some of those jurors, probably the sleepy ones that are asleep, may have already made their decision. But these are some bombshells that more than likely these jurors would not have known until today, because in closing arguments, the prosecution made a PowerPoint. It put the law on the screen, and then she applied the facts to the law. I'll be showing you some expert excerpts from the transcripts as well to bring it together. So first of all, with RICO, she says the first element is that there was a conspiracy or an agreement between two or more people to participate in the enterprise. She explains, I'm going to call it Combs Enterprise. She says, because I said that a moment ago, the defendant was the leader. She says, but I want to be clear. When I say Combs Enterprise, I am not talking about the name of his company. She said Combs Enterprises. She basically wants to make sure that the jurors are not getting confused, thinking that she's claiming that, oh, Bad Boy or Combs Enterprise was specifically created to effectuate and commit these crimes. No, she's saying that it was an enterprise that was simply KK, D-Rock, and other staff members that he had to do specific illegal things, so that there's no confusion, because we all know, no, Bad Boy was not created to be a criminal enterprise, and that absolutely would be a point of confusion with the jury. She also went in and she clarified. She said, now the defense suggests to you in opening statements that there was no criminal enterprise because no one testified that they were part of a criminal enterprise. She said, but members of the jury, use your common sense and look at the evidence. Whether you're receiving a paycheck from a lawful business or not, when you direct other people to get or transport substances for your boss, you're committing a crime. When your boss asks you to buy and bring him substances, this is YouTube talk, you see what's on the screen, and you do it, you're agreeing to commit a crime. When you go with your boss to kidnap another employee and make her take you to someone's house, talking about Kid Cudi, you are agreeing to commit a crime. And when you lock your boss's girlfriend in a hotel room after your boss stomped on her face and won't let her leave, you're agreeing to commit a crime. And what the evidence is going to show over and over is the defendant, quote, and his inner circle agreed to commit crimes together. That's what racketeering conspiracy is. So they really brought it together with very specific examples and dumbed it down. And throughout opening, they were very clear. There absolutely were co-conspirators, KK, D-Rock, over and over again, so that there was no issue of the jury having to wonder, well, how is this a one-man RICO? Oh no, there was no doubt that the jurors were given facts to show that it's certainly not a one-man RICO, but it was a racketeering enterprise where the staff worked together to effectuate these crimes. Then the prosecution went on to include what is probably my favorite bombshell of the day. Subscribe. Now make sure you hit that like and you hit that subscribe. Now, one of my favorite bombshell of the day had to have been when they clarified the RICO predicate offenses. Predicate, which is the underlying crimes, right? Everyone's been talking about, oh, you only need two. You only need two. She says, quote, I want to make one thing clear up front. To find the defendant guilty, you only need to find that he agreed with another member of the conspiracy that someone in the conspiracy would commit two individual acts of any of these categories. Remember, those categories are the bribery, the trafficking, forced labor, tampering with witnesses, the prostitution across states, all of those things. And quote, this is the important part, they can be the same kind of act or different acts. So it could be two acts of substance distribution, meaning giving substances to another person on just two occasions. It could be two kidnappings, or it could be one of each, one substance distribution and one kidnapping. That's all the law requires. And let me tell you, on that one, I had to say order in the court. I always knew that it was two offense, but I didn't know that you could also have two of the same. It doesn't have to be two different. So the prosecutor actually stated examples of drug substance distribution alone were sufficient to convict Mr. Combs of the racketeering charge because the trial testimony established that he directed his employees to transport substances several times for use in the X sessions. All right, I had the wrong page of the transcript up just a moment ago, but now you can see here clearly. This is the section where she specifically says it could be two of these same offenses and RICO would be proven. That then brought us to the bombshell over the substance distribution charge. So regarding the substance distribution charge, the prosecutor confirmed for distribution, there are two elements. One is simply that the co-conspirator distributed substances. And then the second is that the co-conspirator distributed them knowingly. It does not mean anything special, she says. It's just the act of passing substances from one person to another. And let's be clear, she says, of what substances we're talking about. We're not talking about ganja. We're not talking about Mary Jane. She states we're talking about what Brendan Paul last week called hard substances, the kind of hard substances that the defendant fed to Cassie. And then it went on to state the second bombshell, the quote, there is no minimum for the distribution charge. There's no minimum amount. In distribution, she clarified, distribution is, quote, it says you need two elements. One is that a co-conspirator, let's see, we got it. So one is that there's a co-conspirator who distributed the substances, and two, the co-conspirator did so knowingly. They clarified it doesn't matter if the defendant wasn't buying kilos or even selling drugs himself. It doesn't matter that quantities were small and fit inside his Gucci pouch. You heard the defense asking witnesses about whether the amounts were for personal use, meaning the defendant's personal use, but that's just a distraction. The defendant and his staff were all involved. In other words, personal use is irrelevant as long as it was a matter of sharing between the staff people. That's what matters. The law has no minimum amount. The law has no definition of personal use, as in trafficking, major trafficking cases. This is not a trafficking charge. It's merely a distribution charge. And it says here, quote, the defendant wasn't just buying substances for himself. He distributed substances to people around him, including employees and friends, to people around him, including friends, including girlfriends. And of course, substances were an essential part of the freak-offs. And now for the bribery. Now, it states, quote, the prosecutor stated, in their opening, the defense suggested that the $100,000 wasn't a bribe. It was just about publicity. And states, quote, but that's not the full story. Sure, the defendant did not want the public to see the video, but he understood full well what was depicted in the video, and he knew police involvement would ruin him. The two things are linked, of course, they state. A police investigation and criminal charges are potentially ruinous on their own and reasons enough to bribe the security guard. So it says, so sure, he didn't want the public to see the video, but he also didn't want the police to see the video. It's not an either, it's both. And they're stating that for that reason, it's the law. And then they gave this little tidbit fun fact to clarify further evidence and proof that it wasn't simply about getting rid of bad press. The government then goes on to describe exactly what happened in the transaction when Eddie Garcia went to go obtain the $100,000 payment. Defendant puts the $100,000 in a brown paper bag and hands it to Eddie. Says the bribe is now complete. But then on Eddie's way out, the defendant tells Eddie, hey, don't make any big purchases. She states, this moment tells you everything you need to know about the defendant's purpose in paying the bribe. Think about why the defendant said that. Who would pay attention to big purchases from a hotel security guard? Not the press, not TMZ. So, quote, that's how we know that this bribe wasn't simply about making sure there was no bad press, as the defense very wisely tried to attempt to use as a defense. This will be one where if a juror, though, is committed to just saying, I don't want to find Diddy guilty of anything, that juror still may choose to not actually evaluate the facts and the evidence here. But that was key. TMZ is not going to be looking at whether or not some security guard is making big purchases, but the cops would if the cops are investigating whether or not Diddy made that video go away. And now for the charge on the hooker. See, the defense continued to say, they weren't paying for prostitution across state lines. He was merely paying the guys for their time. The prosecutor states, quote, he testified that each time he had a freak off with the defendant, this is one of the former S workers in Cassie, that he was paid between $700 and $6,000. He was not paid for his time. I'm going to spend no more than 10 seconds on this ridiculous argument because you know why Daniel and all the other escorts were paid. They were paid for sex. So every time they had X with Cassie in front of the defendant, that's a commercial X act that is relevant to both trafficking and to, quote, coercion. Now, note the difference between the trafficking and the prostitution. Prostitution is no coercion. They're doing it consensually, okay? That's the difference between prostitution and the trafficking. The trafficking requires coercion, fraud, or force, which nullifies any consent there. And then there is arson and the napping. Arson and napping, again, as I said in my prior video, you can take a look at it. Those charges were not dropped. They're just not going to pursue the attempt because they're pursuing the completion. Now, with arson, here's what is significant. And I've said from the beginning that I believe arson is one of the weaker charges. But, quote, the prosecutor states, quote, this is very clearly arson. The only question is whether the defendant or his co-conspirators were responsible for it. And of course, the defendant was behind this, meaning that's the legal standard. If he or his co-conspirators were behind it, that's sufficient. And then they highlighted and brought those facts. It said, now it shouldn't come as a surprise to you that we're not suggesting the defendant personally cut the hole in Kid Cudi's Porsche. You heard audio notes. The defendant doesn't even buy his own soup, they said. Doesn't buy his own soup. And it goes down further to say he didn't cut the hole in the Porsche. But let's be clear, he was 100% behind Kid Cudi's car blowing up. The defense has tried to suggest to you that there's nothing tying him to the arson, but the evidence and basic logic, they say, suggest otherwise. For starters, he literally said he was going to blow up Kid Cudi's car when the defendant was out of the country. And then she says, here, you see it on the screen, and put on the screen a text message or an email pertaining to that. But I think what was really helpful and important there, as they state that not only are they not claiming Diddy himself was the one that did it, but they're reminding the jury that the law doesn't require for Diddy to have done it. It's only whether the defendant or a co-conspirator is responsible for the arson. In the kidnapping, the facts there, same thing. It was an allegation. But again, they don't have to find that he was liable for the kidnapping. We were also able to see the relevance of the baby oil. It is actually an essential element of proving the trafficking, because one element you have to show is that trafficking affected interstate commerce. They stated, quote, the baby oil was relevant because products in or affecting interstate commerce were also used during every single hotel night. You can check the labels of the bottles of baby oil, which is distributed by a New Jersey company, Johnson & Johnson, and Astroglide, which is actually made in New York, they say, but it necessarily crosses state lines when it's used in California or Florida, meaning Diddy's other locations, residences, and those products are in evidence. So the baby oil actually is relevant for more than just embarrassing Diddy. And last but not least, we have the S trafficking bombshell. Shake that Astroglide as you come in. That's what we do on the channel. Shake that Astroglide, hit that like and hit the subscribe. So with the bombshell there that was shared about the S trafficking. The prosecution stated that proving that women were coerced into simply one freak off was enough for an S trafficking conviction. One for each, one for Jane, and then one for Cassie. It says, quote, if there is one time, one single freak off that jurors found were the product of force, threats, fraud, or coercion, Mr. Combs should be found guilty of trafficking. They have been satisfied the law. And this was critical because a point of contention has been whether or not he coerced the two women. Now, I'm going to get back to that. When we're talking about the evidence of at least one instance where there was force, fraud, or coercion, honey, that best instance is that hotel video. That's why that video is so critical. That instance of the Cassie beatdown video is relevant to the trafficking because that occurred during a freak off. I think it was one of the security guards testified. He went to the door. He saw a male in the room sitting on the bed. Cassie testified they were in the middle of a freak off and that he basically wanted to drag her back to complete and finish or return to the freak off. And the prosecution has stated you do not need a completed act for it to be trafficking. In other words, the fact that they didn't complete having sex doesn't mean it wasn't trafficking. So that one instance and highlighting that the fact that that one instance can be sufficient to find trafficking for Cassie was critical. And then she went on to actually clarify even further. A key point of contention throughout the entire case has been whether or not Mr. Combs coerced the two women, Jane and Cassie, into freak offs, or if they were willing participants. In cross examinations throughout the trial, the defense highlighted multiple text messages in which the women expressed enthusiasm or excitement for those sessions. But here's the tea. The prosecution confirmed the government is not arguing that all of the S acts, the S nights with male escorts, constitute trafficking. No, no, no. She stated that the women had initially been willing to engage to please their boyfriend, Mr. Combs, but later became unwilling participants who complied either because they feared that he would hurt them physically or cut them off, blackmail them, etc. She states, quote, the fact that a victim consents once to a commercial S act doesn't mean that she consented every time. You only need to find that on one of those hotel nights, it meets the element of trafficking, i.e., no consent there. And it seems with Cassie, the perfect night for that would be the night of the hotel beating. So in summation, I have to tell you, in the end, the prosecution did a great job. It was boring as all get out. It felt like you were in a really, really long college lecture. However, but I have to say, even Jane's facts are looking much stronger in this context. Now, of course, the defense is not going to go out fighting. They've got really, really strong jury instructions. They are also using the jury instructions in the charge to really help coach or help the jurors see things in their way. And they're not going to go down without a fight, right? So my prediction at this point, just at the end of listening to the closing arguments from the prosecution, is that I think jurors largely have made up their mind. Many were falling asleep at various points while others did stay awake. Now, if all the jurors actually follow the law and follow the rules, I say there's going to be guilty on RICO. There would be guilty on the trafficking, the prostitutes across state lines. And I actually say because of the fact that it only has to be one incident where each of the ladies did not agree, did not consent, just one, I would say guilty on the trafficking for Cassie because that video shows she was not consenting that day. Hotel. She was trying to leave. I still say for Jane, I could see either a not guilty or a mistrial on Jane's trafficking charges. And this is what would likely happen unless we have what's called juror nullification. Juror nullification is when a juror says, I know the rules, but I don't want to follow them because I don't want Diddy to go to jail for anything. And that actually was why it was so critical that they got rid of juror number 6 at that point, because the judge felt that a juror who simply can't clearly answer the question of where do you live would have difficulty following the instructions. And jurors who don't follow in the instructions ultimately do what's called juror nullification, in that they do not follow the rules. They do whatever they want. And they say, I just don't want this person to go to jail. Keep in mind, they don't get to know that he's facing, if convicted on all of these, a minimum of 15 years and up to life. They don't get to know that. They only get these facts in front of them. And I have to say, the strongest two predicate RICO offenses, I'm actually going to amend what I've been saying on the channel previously. I actually think the strongest, previously I always said that it was the prostitution, bribery, tampering with witnesses. I'm actually going to say that it's the bribery, the prostitution, and the substance distribution. I'm taking away the tampering with the witness and the obstruction, because for those, with the tampering, you actually have to find that there was something that was going to be reported to a federal officer. So whereas previously I thought the tampering could also be how they bribed and tampered with the hotel workers to get the video. No, no, no. The government said that's not the tampering and the obstruction. The tampering and obstruction is actually Jane and Mia. There were incidents after Cassie's lawsuit where basically Diddy went to them and tried to get them to change their testimony or change what they would say to be supportive of him because he knew a criminal investigation was coming. And when he did it with Jane, Jane actually had already started talking to federal investigators. So hypothetically, that would have been to get her to change her testimony to a federal officer. Notice we never heard anything about the obstruction of justice regarding the Kalina, which was the woman that was in his group. And Kalina was part of the basis of the reason he did not get bail. Remember, they stated he should not get bail because he was obstructing and tampering with witnesses. Kalina specifically had an appointment to meet with and sit down with federal investigators, and he called her 154 times in the week prior to her sitting down with the federal officers. We don't know why Kalina did not testify in this case. I don't think she's cooperating. It was alleged that he did pay her some money and that Kalina was in some financial bind. Either way, that wasn't included. And we will have to see if he's even found guilty on the tampering with witness, or what happens is, well, have to agree on each underlying predicate offense. If he's not found guilty of that tampering with witness, that means he would have sat in jail all this time without bail for something that apparently it would appear that the jury didn't even agree with. So, y'all, what do you think? Is the government's case enough to convince a jury? What do you think? Or will Diddy's fame cast a long enough shadow to block a conviction? Next up is going to be my breakdown of the defense's closing. That's going to take place later today. I'm doing this early in the morning so I can get to court, and then the prosecution's rebuttal. Now, remember, jury instructions are going to be key here, and they've not yet been released, but we're going to go over them on this channel as well, probably over the weekend. Those jury instructions are supposed to be around 30, 40 pages. This poor jury. So let me know in the comments. Don't forget to like, share, subscribe, and don't miss my verdict breakdown next week. When we get, I think we're going to get a verdict next week. This is your legal bestie, Attorney Symone at Girl, Is That Legal? Oh, and I do think, I think they're going to deliberate. I think perhaps we'll have an answer by Wednesday because court is on Thursday and Friday for the holiday. I think if we don't get an answer by Wednesday, we will likely at least receive notice from the jury that, hey, maybe they're hung on a charge. They can hang on any individual charge without it impacting any of the other charges. It's your legal bestie, Attorney Symone. Have a great day.
Is that legal?